Court of Appeals versus Appellate District of Ohio, with the Honorable Candace Strauss presiding, is now session. Please be seated.
Good morning, everyone. Okay, we have today three cases set for argument. We are going to take them a little bit out of order because for the final case, Judge Zayas will be sitting in for Judge Bach. If the attorneys would just state their appearances and their readiness to proceed when I call your case. The first case to be argued is C-24-0555, and that's State of Ohio versus Jeffrey Baxter.
Good morning, Scott Heenan on behalf of the state. Ready?
It's Johnson for Mr. Baxter.
Good morning. The second case set for argument is C-25-0031, and that is Daniel Quayle versus Bonnie Roberts.
Full carriage to Bonnie Roberts, ready to go.
Nicholas Kulik on behalf of Daniel Quell, ready to go.
Great. And the final case is C-24-0689, David Dornett versus Green Building Consulting, LLC.
Nick Kazanka for Mr. Bonnet, and we're ready to proceed.
Okay.
Nicholas Schwander for Red Knot Homes, and we're ready.
Okay, and just to let the parties on the Dornett case know, we're going to be taking a brief recess so that Judge Zayas can join us and Judge Bach can leave. All right? All right, so for the first case is State of Ohio versus Jeffrey Baxter. Mr. Heenan, would you like to reserve some rebuttal time?
Just 3 minutes.
3 minutes.
So, about 2 weeks ago, I actually argued the exact issues that are before you today in this case in State versus Stonewall. It was your other three colleagues, so got all 6 of you now. But it was the exact same arguments, and really, in many ways, Hall controls the outcome of this case. So, unless there's any real specific questions that this panel has, I feel that between Hall and when Stonewall gets decided, that's what Baxter is.
Well, I mean, not everybody was on Hall.
That is true. You were not. You were not. But I believe that right now Hall is the most recent decision from this court. En banc consideration was asked for. It was denied. It is currently on appeal to the Ohio Supreme Court. They've yet to accept jurisdiction on it. I can say that every case from this court that has had any real analysis of Bruin or Rahimi has been accepted by the Ohio Supreme Court.
And stayed.
And stayed for Striblin,
Yeah.
which is getting argued in October. On Hall, since I've been acting as Mr. Wessels as best I can while he's out, I did file the response to jurisdiction in Hall. They raised two propositions of law. The first one that was not Bruin, I was like, no, don't do that. But the Bruin one, I was like, yeah, you need to just take and hold this for Striblin like you have everything else. So eventually we're going to get some guidance from the Ohio Supreme Court on this. I don't know when that'll be. I'd love to think it'd be this year. But with them hearing argument in October, realistically, I think it might be early next year before we get that. I'm hopeful to be this year, but I've done this long enough to know that it's a complicated issue. It might take them a little bit longer to do.
So would you urge us to stay this?
Normally, I would, and in most of these, when I'm going to come up here, I would ask you to hold it for Striblin. The only wrinkle that we have here with Mr. Baxter, and it's specific to Mr. Baxter, is, and this is not in the record on appeal, but after this appeal was filed, he was picked up in February for resisting arrest. And then in April, he was picked up on a new CCW, this time not just based off of his age, but also based off of him having that resisting arrest conviction. So to the degree that in this case there's a little bit of a wrinkle, it may help the trial court to get a decision on this, but at the same time, if you say this is stayed, I can very easily go to the trial court and say, hey, the Court of Appeals is considering this, they've stayed it, you should sit on this and wait on this too.
But you're not specifically asking us to stay it.
I think that's, I mean, honestly, while it might help iron out the wrinkle, I do think that ultimately the right thing to do in all these Bruin cases is to wait for Striblin. Otherwise, all we're doing is whoever loses is going to appeal to the Supreme Court, and they're going to get in, and then the Supreme Court's going to stay it.
How is
And-
Striblin though? I mean, Striblin's a firearm and a liquor establishment,
is.
and I was looking at what they're gonna be looking at. How is that case even gonna be helpful to us in what we have here?
I wish I could answer that for you. I just know that the Supreme Court has taken all of these in and held them for Striblin. Now, whether or not when they issue Striblin, they're going to say, remand it back to you, saying, hey, here's our new guidance. Apply it. I don't know if they're going to do that. I don't know if somebody's going to stop holding all these cases and ask for briefing. I really don't know.
I just feel like how long is that gonna take? I mean, Striblin, to me, doesn't seem like it's gonna be that helpful. It's not even gonna be argued until October, which we've seen, we have cases we're waiting on right now that were argued in February that we don't even have anything on. So
I recognize and appreciate.
we're gonna be
all that.
leaving the trial courts below without any guidance at all if we stay everything.
Well, I mean, right now, they do have the guidance of Hall, which I like, so. But, again, all the arguments have already been made to everybody on this panel. In fact, everybody on this entire court has heard all of our arguments, and they're well briefed by Mr. Wessels. And I would just ask that on the authority of Hall, if you decide this, that you reverse and send this back to the trial court. I recognize then that Mr. Sinclair will take this to the Supreme Court, where it'll get held for Striblin. But if you're going to rule on it, then you should follow Hall and reverse this matter.
Is there another way that we could find in favor of the state here without following Hall exactly? Because it's a slightly different issue.
Well, I mean, the issue here is whether or not being under 21 was something that the state could prohibit. And when you look at the history, and this is, again, we talked about this a lot when we argued Stonewall. In fact, it's kind of amusing. Judge Nestor and I legally, historically, and scientifically showed 18 to 20-year-olds are idiots. The fact that my 16-year-old reluctantly confirmed. And admittedly, myself, remembering my own 18 to 20-year-old days, I agree. But historically, people under 21, they weren't allowed to have guns. If they did, it was because they were put in a situation where they had to have them, such as they were put into a militia or a military. But even then, they were always supervised. And even when they joined the Army, a parent could just say, you know what, I've changed my mind, send them back. And they had to send them back because until you reached the age of 21, you were considered an infant. And
But you're not anymore. Now it's age 18. And are we going to say that once somebody turns 18 and they're legally an adult, and we as a society don't even have to take care of them, the parents don't have to take care of them anymore, that they don't have their gun rights at that point?
well, the Supreme Court's told us to look at the history of the Second Amendment to see what were the rights when the Second Amendment was formed. And when it was formed, 20-year-olds couldn't have guns. And even today, yes, when you turn 18, you become an adult, you get the right to vote, you can't drink.
Well, drinking's not a second, or
It's
you
not a
don't, you don't have a
second-
right
That's
to
true,
drink.
you do not. But again, when you look historically at what were the constitutional rights that infants had at the founding, it really wasn't any at all. That their parents had all those rights and controlled them for those children, infants, kids, whatever you want to call them. That is the history of this. And even if you want to step beyond that, if you want to say that, all right, 18-year-olds, for whatever reason, whatever it was 200-something years ago, today it's different. Even then, that would not have, now that he's got these new convictions, he's got some other problems. But at the time that this case was taken, when he was charged with this case, at that point in time, he was allowed to carry. He just had to openly carry. He couldn't carry a concealed weapon. So he was able to exercise his Second Amendment rights. He was able to carry a weapon in defense. He just couldn't conceal it.
But with your logic, if we would go with your logic, then 18 to 20-year-olds would have no gun rights at all. I mean, it would be constitutional for the state to take away every right, not just concealed carry.
That is the unique and bizarre test that Bruin has given us when we're looking at the history and tradition and what was the law at the time of the founding.
So you think it would be constitutional to take people now who have reached the age of majority and to say they have no gun rights whatsoever because that's what they did back in the day?
Under Bruin, that argument could be successful, yes.
But what about Rahimi? Doesn't Rahimi loosen that up a little bit and say we don't have to necessarily find a twin?
Well, I think that that decision was because obviously some things have changed. So let's look at the improper handling of a firearm in a motor vehicle. We didn't have motor vehicles when the Second Amendment was adopted. We didn't have an interstate system. We didn't have any of the stuff that we have today. We didn't have some of the weapons that we have now that are things like, that can't have, like fully automatic machine guns and stuff like that, or Glock switches. I think that's where they're looking for that, because some people are looking at it and saying, you had to find that exact match from back when the nation was founded. And they said, okay, that's going a step too far. You don't have to find an exact match. You can still find something that's analogous.
Right, and so how far can we go? Can we look at just dangerousness
I think
as a
dangerous
category?
Dangerousness is obviously an element that was considered, and people who were considered dangerous, and that was how Judge Nestor and I got to the stuff of talking about idiots, and that's because when the Second Amendment was founded, history's words, madmen, idiots, and infants weren't allowed to have guns.
And the legislatures are the ones who determine what's dangerous or not, right?
Correct.
And so if our legislatures today considered some action to be dangerous, that would be consistent with the histories and traditions of Second Amendment restrictions.
Yes, and that's why we still have weapons under disability and are able to charge people with weapons under disability for different things that would cause them to be considered dangerous people.
So as long as we can link it to dangerousness, then it's consistent with the history and traditions. Is that?
Would we? Yes.
I guess we don't have any more questions for you.
Nope.
All right, well, in that case, I just ask that if either hold it, which I realize is probably not the most practical request, to then just reverse.
Okay, and you have a little over 4 minutes left for rebuttal if you want to use it.
Good morning, John Sinclair from Mr. Baxter. And
Morning.
as you can expect, I'm a big fan of the Barber decision. Any questions? No good.
I do. So this idea of 18 to 20-year-olds looking historically, they were considered infants. They weren't allowed to do much of anything without their parents' permission. Are we to look at the actual age up to 21, or are we to look at what is considered a minor?
Well, as you can see in my brief, I cited I had 3 different federal circuits that have dived into this issue, and they dived into it. They said, are we going to say that 18 to 20-year-olds are any different an adult than a 21-year-old? And they dove into that in Laura. I know that you've seen that, the Laura case versus Penn State Police, the Reese case versus the ATF, and then the Worth versus Jacobson. But all of them came to the same decision. There's just no distinction historically between the 18 to 20-year-olds and those that are 21 and older. And I think they kind of exhausted that issue, and they came back and just said there's just nothing there. We don't have that historical tradition.
Counsel, let me,
Different.
I'm sorry to interrupt.
Yes.
On the historic tradition piece of it, how much deference should we really give to that historic piece of it? Nobody on this bench could have participated in making those laws or electing the people that made those laws. So why and how much deference should we give to laws that were made during a period when most folks couldn't even have participated in our democracy?
How much deference to?
To determinations of who's dangerous and who's not dangerous.
What are you saying, that why are we looking at those?
How much deference do we need to give? If in the 17 and 1800s they considered people who are 18 to be infants and therefore dangerous. How much deference do we need to give to those insights now? Shouldn't we defer to our current legislature to determine what's dangerous?
Well, I don't think that's what the first Bruin decision said.
But Rahimi gave us some room, as I
Right.
mentioned.
Right.
So we have some room to operate
Right.
here, right?
Right, and of course, the tough situation with this dangerous argument is what we just heard 15 minutes ago, which I heard Mr. Heenan said that, 18 to 20-year-olds are idiots. And then, of course, the bench quickly pulled out or pointed out that 18 to 20-year-olds right now can walk on our sidewalks right now with open carry. So we consider it more safe for an 18-year-old right now to be walking down the sidewalk with a gun on their hip, but not in their pocket. So we know, and I think this was pointed out in Barber, that our legislature right now has zero problem with 18-year-olds walking down the sidewalk with a gun on their hip. So I don't know how we,
Right, the issue is that the concealed carry is dangerous, right?
right. Right, and I noticed in Hall, that Hall, came to this conclusion that there's a reduced risk of unwarned shootings by hidden guns, which was a finding and a discussion in Hall that the state never developed in their own brief.
But
and
it comes from the case law of your, I mean, this is all quotes from prior cases in our nation's history and tradition of why concealed carry was considered to be dangerous.
In a few states. I understand that, actually, I think if I read in Hall, actually that conclusion came from 3 different states in the South. I think it was Oklahoma, 3 of them. So I just don't, I think Bruin certainly said we don't pick and choose and just make our decisions based on 2 or 3 states from 1860.
There were more than 3 states that outlawed concealed carry back in the day.
I think, actually, Hall said that only 10 of 34 antebellum states had some CCW restrictions. So I'm not sure how we rely upon the fact that 33% of some states did have CCW laws, but so therefore that is logic to support what the state is suggesting today.
So how are you asking us to analyze this case? What are the steps we go through?
I think it's a very difficult case for the state to prevail once because in the other cases we have disability issues, we have the appellant himself has an issue of trying to conceal carry, but at the time of his arrest he was under indictment and so on. So in this case, Mr. Baxter doesn't have any of those issues as an appellant in any of the prior cases that this court has heard. 0. He is a 18-year-old who is allowed right now to carry openly. And our legislature says that's not a danger. So,
But they did say having a gun in the car without a CCW license is a danger.
Yeah, but I think all
Is that accurate?
all guns in a car are concealed, I think, right?
Did our legislature say that having a gun in the car without a CCW is dangerous? Is that the conclusion that they reached in adopting this law?
Well, I know that right now, of course, an 18-year-old can carry in a car. So improper handling, again, doesn't even apply for an 18-year-old. So I'm not sure.
How does that, can you explain that a little bit more?
Well, it's my understanding that improper handling right now, again, for an 18 to 20-year-old is permissible in a car. But anyways, what I was explaining, that of course every gun that's in a car is concealed.
Oh, I see what you're saying,
Person
okay.
going by. But to answer your original question, Your Honor, because the other appellants have other issues, they're under indictment or they have an old juvenile adjudication from 20 years ago and this one doesn't, I really don't see how the analysis can be any different than what the 3 different federal circuits did. They just said, how do we treat adults differently? Or what is the historical tradition that shows we treated 18 to 20-year-olds differently? And I don't think that they all found that it's not there. three different circuits said it's just not there. We don't have the evidence for it.
So the NRA versus Bondi case, in that case, it was a sales case, but it found that a state law can restrict sales to 18 to 20-year-olds of guns. How is that different or the same or?
And I think actually that sales issue was exactly the issue in Reese versus ATF, and I know that it came to a different decision. So I'm not sure, I don't have it right in front of me, but I don't know if the Bondi case came prior to Reese versus ATF or not. But I just know that that's
I think it might have. I think that one, I think NRA v. Bondi was in March, maybe?
So, again, it almost seems like that we're going to have federal circuits having contrary decisions. And as I told my colleague before he walked in here, I don't know that we'll ever have a final decision on many of these issues until it gets back to the U.S. Supreme Court. I don't know, because I do think, just based on your last question, it almost seems we have federal circuits that are now having a different position on this exact issue of 18 to 20-year-olds purchasing, possessing, concealing.
How do you feel about the issue of a stay of all of these cases?
I can't, how can I argue with that? I think that that discussion you just had is so true right now. The state of the case law in Ohio, the state of the fact that we're waiting for the Ohio Supreme Court. Of course, I wish my colleague didn't bring up what has since happened to Mr. Baxter since my appeal, but it is
But you
true.
you can't argue for or against the stay.
Um,
Are you saying that we should proceed and decide these cases, or we should
yeah.
wait?
So I'm one of those rare appellants from the defense who's the winner up here. So I'm appellee. So of course I'd very much not like to have the stay. And because the issues of appellant are really kind of pre-pure, he's just at the time of his appeal, he was an 18-year-old who just wanted to have the same rights as a 21-year-old. So I wouldn't be asking for a stay. I just think that the law's already been fleshed out as to the historical analysis. It's just been exhausted, and I just think, and I'm not saying federal circuits are any smarter than our state district courts, but I just think they've dove into this very, very intently and many different decisions, and they find that if you were to apply their findings, then Mr. Baxter would prevail here.
So you're saying on the Hall situation, the Hall case, that you disagree with the logic that there is a history and tradition of prohibiting concealed carry?
I believe that there needs to be evidence more than citation of a number of states. And I do know
Like what?
that-
Like what
Sorry?
what kind of evidence would need to be?
Well, I just think that if you were to say that there are 2 or 3 states, I don't think that comes up to a level of evidence. And this is what all those 3 different federal circuits said. They said the same thing when this analysis was done with history. They said the fact that you found a couple examples of Kansas in 1850 doing this, but then 32 other states didn't, that's not evidence.
Didn't even Bruin mention that there, I mean, it was dicta, but there was a history and tradition of restricting concealed carry?
Right, we know, right, in Bruin, of course, it was a reverse situation in New York where they were doing the opposite analysis here about whether or not you can restrict open carry.
But they seem to indicate that restrictions on concealed carry might be constitutional.
I did, sorry, I just can't recall that part of Bruin.
Okay.
Yes, Your Honor. But yeah, I mean, I just can't say it much better than in Barber. I mean, when Barber said that if we're going to talk about dangerousness, why is it our Ohio legislature says, and Mr. Keenan even says that our 18 and 20-year-olds can carry openly. right now with actually no license, no education at all. And yet, we want to find that they can't concealed carry. But we don't even have the evidence. I mean, the state brief didn't even develop anything about any evidence, which is a number of federal courts have said, show us the numbers where 18 to 20-year-olds, who we all assume are law-abiding, none of us are assuming any of these persons would be anything but law-abiding. Why are they more dangerous as a class for concealed carry between 18 and 20? And
Is that proper, though, for a Bruin analysis? It seems like more of an equal protection kind of thing.
Well, we do go back and forth. We go back to the historical analysis, and it's hard not to touch upon the current modern situation.
Because we can't really do a weighing, right? We just look at history and tradition.
It's true. You're right.
Okay.
Thank you.
All right, thank you.
Just very, very briefly, since we brought up other jurisdictions, and I did not update this list this week, but when I was preparing for Stonewall, I checked, and yes, the Eighth Circuit in Worth versus Jackson said that the under 18 was unconstitutional. However, when I did a national search, Illinois has come to a different conclusion, Nevada has come to a different conclusion, and Pennsylvania has come to a different conclusion. All those states that have considered this issue have said that a ban on CCW for under 21 is perfectly constitutional.
And why is that? They said did they say it was the history and tradition that CCW bans were?
They went into that you did not have the right to the concealed carry, and that it was the history and tradition. Yes, again, that under 21 wasn't allowed to have guns at all. So that's what it was. It was a mix of all this. So again, as Mr. Sinclair pointed out, at some point the U.S. Supreme Court is going to have to clean up the mess that they've made with Bruin, which I hope they do.
They tried with Rahimi.
They tried really hard, and I appreciate their effort. The other thing I would point out is that there was talk about, well, what's different? You know, once you're 18, you're an adult. The thing that struck me when I sat down is that it's true, but if Mr. Baxter with his if Mr. Baxter committed his resisting arrest when he was 17, the juvenile court could keep jurisdiction over him until he's 21. And that's a decision that the Ohio legislature has made, that juvenile courts, if you do it soon enough, can keep you until you're 21. So that age of 21 is still lingering, even in our modern law today. So there's that. And the other thing is that I know that when we talk about the weapons under disability, that this court has said that, hey, there has to be some objective standard that lifts that disability. To the extent that he has a disability that prevents him from carrying a concealed weapon, I can't think of anything more objective than his 21st birthday, which is etched in stone, will never change, and will absolutely happen on a fixed day and time. And from that moment forward, he will no longer be under this restriction unless he does something else that puts him under a disability. So ultimately, at the end of the day, I would ask that, again, if you want to hold this for Striblin, I won't stop you. I think that'd be great. But at the same time, I recognize that could become a long wait, and that if you need to put the decision out, that I would ask that you reverse. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Okay, our next case is Quell versus Roberts. Mr. Carriage, would you like to reserve some rebuttal time?
4 minutes, please.
Okay, I will keep your time. Whenever you're ready.
May it please the court, my name is Paul Carriage, and with Maddie Wilhoit at counsel's table, I represent defendant appellant Bonnie Roberts. So I'm going to start with telling you what I want you to do, because I think it's a little bit complicated. So the trial court initially adopted the magistrate's decision and then reversed itself and sustained objections to the magistrate's decision. So what I want
That was before objections were filed.
That's absolutely correct,
Okay,
before
okay.
objections were filed, which is entirely normal and
Yeah,
proper,
okay.
nothing unusual about that. But what I want this court to do is reverse the trial court's decision sustaining the objections, which would necessarily reinstate the adoption of the magistrate's decision. That's what we're asking the court to do. Wanted to spend a minute on that because it's a little more complicated than perhaps a normal reverse. So there are 4 topics on the agenda. The first is I want to briefly talk about the standard of review. It's going to be real short, but I want to talk about it. Then I think the 3 remaining topics all fit under a broader umbrella of neglect of the children. That would be neglect in addressing mental health issues, neglect in addressing the social and behavioural issues, especially related to electronic devices, and neglect in addressing the lack of educational progress. Now, whether these are viewed individually or together, I think we end up in the same place, which is a change of circumstances, and that it serves the best interests of the children for their primary custodian to be their mother. So let me touch upon the standard of review real quick. The standard of review is abuse of discretion. That part of the equation is not in doubt. The problem is once you dig a little deeper into why the standard is abuse of discretion, it's because this court has a cold record, whereas the trial court gets to observe witnesses and see demeanour and all those kind of things that we would normally expect. But the trial court upheld the objections based on a cold record. It was the magistrate that viewed the witnesses and saw the demeanour. So although the standard is abuse of discretion, the rationale for the abuse of discretion standard here really makes much more sense to defer to the magistrate, not the judge.
So are you asking us to change the standard of review?
No,
Okay.
the standard of review is abuse of discretion, but what I'm asking you to do is, well, so let me back up a step. Look, I don't think it makes any difference whether you apply an abuse of discretion standard directly to the trial court or you sort of jump over that and go down to the magistrate's decision and look at that for whether the magistrate abuses discretion. I don't think it makes any difference here. I think there was an abuse of discretion to uphold the objections. That said, if you disagree with me on that point, I think you've got to kick the tires a little bit on the rationale for the abuse of discretion
Well,
standard.
doesn't the trial court have a duty to independently review the record?
The trial court does have a duty to, absolutely true, to independently review the record. But here, the trial court independently reviewed a cold record, which is exactly what this court is told, don't reverse based on a cold record unless it's an abuse of discretion. So
But that's on credibility issues, right? Like witness credibility issues. I mean, your main issue right here, the first issue is change in circumstances,
Absolutely.
which isn't that a legal call?
So I don't think it actually is. I'm sort of not helping myself in saying that. I think changing circumstances can be a fact-based issue. However, in this situation, it's so obviously a change in circumstances that
If the facts aren't disputed, like the facts are what they are, then wouldn't it just be a legal determination?
yes.
Okay.
But assuming the facts are not disputed, right. And the facts aren't disputed here.
They don't, I mean, the major facts don't seem to be disputed.
Right.
Okay, like that certain things occurred with the mental health, with,
Yes.
you know, all of these things that you're pointing to occurred.
Yes.
And then the issue is it a change in circumstances? The magistrate said yes, the judge said no. It's a legal thing. And you cite numerous cases in your brief to say,
Yes.
wait a second, the judge was wrong because all of these cases have demonstrated it's a change,
Right.
right?
Once the facts are undisputed. That is entirely correct.
And you're saying in this case, the major facts are not disputed.
That is correct.
Okay, so it's a legal issue.
Yes, so now you're de novo on changing
Okay,
circumstances.
all right.
Okay, so let me now, having I think made more of a mess than I needed to, let me try and clean that up a little bit. Let me talk about the mental health crisis. As I think the court has already said, there's plenty of cases saying mental health issues, particularly this severe, would create a change in circumstances. I want to highlight Jones versus Wall, which is a case out of the 12th District, and just compare some facts from that case. So there, the child, in Jones versus Wall, the child began visiting, quote, extremely disturbing websites. Here, the older child visited websites after researching how to commit suicide by cutting. in Jones versus Wall, the child began engaging in self-harming behaviours. Here, we had a suicide attempt by cutting, which was after the father had declined to take the child to a suicide risk assessment after learning of the online research. And also the child apparently considered jumping out of a window. That's less evident on the record, but it's in there. And then in Jones versus Wall, the child had mental health issues and was hospitalised for suicidal ideation. And here we have the older child with audio hallucinations and was diagnosed about suicide and was diagnosed with depression and adjustment disorder. I think that's plenty for this court to reverse on a change in circumstances, just on the mental health issues.
And just to be clear, because I think you had this in your brief as well, father's objections did not challenge that
Correct.
finding, right?
Correct.
They were focused on best interest.
Correct.
Okay.
And there's no challenge. So I don't know if the trial court upheld an objection that didn't exist or just decided based on an independent review. It wasn't clear to me because of the trial court's decision. It's pretty short.
Okay.
It's pretty low on detail. So let me just compare the two reactions to the mental health issues between the two parents.
So this is getting into the best interest?
This is getting
Okay.
into the best interest. I want to try and take the
Yeah.
three major issues one at a time. So Mr. Quayle knew the child was suffering from suicidal audio hallucinations and told her that her behaviour was like that because she was possessed by demons.
Was that, I thought that I read in the transcript that he testified that he said that after her suicide attempt, not before.
His testimony was, I said that at least once, including.
Okay.
He threatened to kick the children out of the home because of their behaviour, and he rejected medical advice at least twice regarding treatment, first for the suicide risk assessment and then afterwards for the signing her up for outpatient treatment.
Okay, I want to back up. I want to focus in on that just a little bit more. So it's my understanding that in March was when the child did the search on the internet, and then the following month is when she attempted suicide, and father took her to Children's after that, correct?
Yes. Father took her to Children's.
Both times? Because I thought I saw records from Children's Hospital in March 2023 as well.
So my understanding is that father took her to Children's and the suicide risk assessment was not completed.
Okay.
That's
So-
my understanding, and if I'm wrong, I'm wrong. That's my
Okay.
understanding.
So next question, though. From, I think it was August through November, the holdup wasn't because father wasn't trying to get her into therapy. It was because the parents didn't agree on the therapist, right?
It was because father didn't want to drive 40 minutes to a therapist.
Well, no. He had one chosen nearby, and mother didn't agree with that one.
So mother chose, and I think this comes down to, like, it's more than saying there was a disagreement. Mother chose a therapist who was a specialist and could address all of the children's issues. Father chose a counsellor or a therapist who was not a specialist in all of the children's issues.
Well, I mean, but
So I don't think it's...
But to argue that father refused to get her into therapy until ordered by the court in November, I think that that's disingenuous, because he attempted to get her into therapy, and they did not agree, for whatever reason, they did not agree. So,
Sure.
I mean, will you concede that he attempted to get her into therapy before that court order?
So I think I would phrase it a little differently. I would concede that he tried to get her into therapy that would have been inadequate.
Okay.
But yes, he did try and get her to see a therapist, and I think the record shows that that therapist was not appropriate for those conditions. So, I mean, you can put that into the best interest analysis, I think, where you like. I don't think it would make any difference.
Okay, but I'd like to move, Actually, I do have a specific question for you. Are the children's in-camera interviews anywhere in the record?
So, my understanding is they are not. And the reason I am saying that with a hint of I'm trying to choke out a way of saying this without insulting the trial court, but the trial court apparently reviewed the in-camera interview that's not there. So I'm trying to work out what happened. So the trial court said, the trial court said I reviewed the in-camera interviews, but they're not in the record. So we assumed that they were in the record until we found out much later that they were not, and of course they're under seal, so we can't see them anyway. But it turns out that they're not in the record, much to our surprise.
Was there a record made? Do you know that?
So I don't know, and there's nowhere in the record where we can tell. I can't tell in the record if there was a record.
There's nothing under seal in the record.
That we can not that I can find. So I'm left with this very difficult situation where I was led to believe by the trial court's decision that there was a record of the in-camera stuff, but apparently there isn't. Which I'm probably best off just keeping my own counsel with everything else I have to say about that, because I don't think it's going to go in a good direction. I want to touch quickly upon...
You are at your, if you want to reserve 4 minutes.
Wow, I'm going to change my reserve down to 2 minutes and go real quick.
You got it.
So, if that's okay.
Yeah, that's fine.
The neglect statute, which is 2151.03A4, defines a neglected child as one whose parent refuses to provide special care made necessary by a child's mental conditions. I think that's where I would circle back to appropriate therapist. It's special care, not just some kind of care that might not be appropriate. Let me real quick touch upon, I don't think I have to say a whole lot about like the 11-year-olds, 12-year-olds drinking, engaging in sexual behaviour, especially online. I think there's plenty of cases saying that's a changing circumstances. I don't think I need to fight that.
So did all of those instances happen when the girls were with their dad? All of them?
So let me be clear about this. The instances of that happening are half of the problem. The other half of the problem is the reaction to them. Kids do things like send naughty messages to each other, for want of a better expression. The reaction is the problem. And father took the phone away for a day or two. Mother disabled devices, strict protocols for screen time. You can only use your phones when you're in a room with me at the same time. I'm taking your phones away at night. That's about appropriate parenting rather than abdicating responsibility. I'm going to take 10 seconds to talk about education. The grades are dropping. Thanks for your time. I'll pipe down.
You'll reserve the rest, okay.
Thanks.
Good morning, Your Honors. May it please the court. Nicholas Kulik on behalf of Daniel Quell, the appellee. The trial court here did not abuse its discretion when it determined that a change of circumstances did not exist and found that it was not in the best interest of the children to modify the parties' agreed entry and change custody. The parties divorced in Washington State in 2017 and had 2 minor children. That same year, mother was investigated by Children's Services in Washington State for neglect and then left in
Are we to look at what happened back in 2017, or are we supposed to look at what happened from 2020 forward?
For a change of circumstance, we do look what's happened since the last court order with
Which was
the
in
agreed
2020.
entry. Correct. I do think it's important as a statutory factor for custody where the parents are relocated. So that was just kind of setting the stage. It's not a factual issue even in dispute, but it is still the mother then relocated to North Carolina. So since the children were 3 and 5 years old, they have lived in father's home in Sherwood, in Forest Hill School District, and where they attend Sherwood Elementary. So father moved to Cincinnati to be with his parents and family that was in the area for the children, and also to be close to mom when she relocated.
What about mom's relocation to North Carolina? How does that factor into the best interest analysis?
Well, it is a statutory factor if you've established a residence outside the state of Ohio. So she did it before she filed the motion, But the fact that she's still there and residing there, I think is very important for this case. One, because it's a statutory factor, she established residence outside, but also that this is an extreme change for the children. They have lived in the same home since they were 3 and 5. They're in an excellent school district. Despite the appellant's arguments, the children are getting straight A's in school and doing very well. And so they have friends there, and they're entrenched in the community with family also there. So to move them, it's not just simply changing custody, it's also changing them to a different part of the country that they don't even know. Mom gets 6 weeks of parenting time every year. That's partly due to geography, but they're not familiar down there. And in fact, it was testified at trial that she didn't have a clear plan for therapy or for schooling when they were going to go to North Carolina. So if this court reverses that, she might have come up with a plan by now, but at trial, she didn't even know where they're going to go to therapy or go to school.
So I'm a little bit confused. You just said the children are getting straight A's.
Right now, they're getting straight A's.
Okay.
At trial, it was testified, well, this is a factual dispute, because at trial, there's evidence.
Because I'm trying to figure what's in our record.
Yeah, so in the record, the children's grades dipped slightly for one semester. So the magistrate decided that that was an extreme drop in grades. You know, they had one semester, the grades went down. Father took immediate action. In fact, it was testified by the school officials that he was emailing the school every single day to find a plan of action to get the grades back up. And by the time they went to trial, the grades did go back up. The magistrate completely ignored that. They saw one semester of grades go down. They weren't even failing, they just went down a little bit, and then saw that that was a huge drop in
So
school.
we have in our record that the grades went back up.
Correct.
Okay.
By the next semester, because this trial was going on during the school year, so grades are going to change. So they did better, and they have a history of doing well. They've had no history of failing or getting held back or anything like that. And father was testified at trial, and the record shows that he did everything he could to help with the grades.
Tell us what's in the record with regard to Judge Bach's concerns on the mental health treatment issue. What's in the record regarding that?
So the record shows that the child did did an internet search about self-harm, and then did self-harm. Once father found out about it, he took them to Children's Hospital. I mean, immediately, to see what was going on. He spoke with the professionals and then took the action that was necessary.
But he didn't take the recommended action. He delayed getting her into therapy. He didn't even try to get her into therapy until, I think this happened in March and April, until at least August. Is that correct?
Yes, and
that was against medical advice.
yes, and I think he admitted to it later that he struggled with the child not wanting to go to therapy. So the child
Well,
saying
you know
no,
what? Kids
the fathers can't.
don't want to
Of
do
course.
stuff all the time, though.
Of course, and there's a dispute between the legal profession and the mental health profession that if a kid doesn't want to go to therapy, is it going to be helpful or not? So, and he did say, later on, I should have forced my kid to do it. And he made, a wrong parenting mistake there. But then he wanted to get the child into therapy and was working with mom to get a therapist, and they couldn't agree on one. And so a large portion of that delay was based on the parents who had joint custody, could not come to an agreement on the therapist. And they eventually did throughout litigation, but before it was filed, they couldn't come to an agreement, and then that's why the child wasn't in therapy.
So by the time of trial, the child was in therapy? Or
Yes,
was not?
correct.
Was in therapy?
Yes, correct.
Inappropriate therapy?
Yes, and agreed upon
Agreed upon by everybody?
therapist.
Okay.
Yes, correct. Mom and dad both agreed to it.
What about the issue that's very concerning about these adult online predators and the stuff that was going on online?
So it is in the record that by the time it was trial, because testified to, that the child's phones were gone. So there was an issue monitoring the phone. Now, both parents, mom was monitoring the children the whole entire time. She had an app that could remotely monitor what the kids were going on and didn't take action on that. The kids were still able, she could have blocked, this access, these messages, internet searches.
I thought that she testified that even though she could see what was going on, because she didn't actually have the phones physically, they were with the kids at dad's, that she couldn't block access.
To my knowledge, she could. You are correct. I believe she might have I think she testified that she couldn't, but it was our contention that that's not accurate. She could have.
Okay, so there was conflicting testimony about,
Whether or not she could block.
okay. Are we allowed to, never mind, forget that question, go on.
And then father testified that he wasn't aware of that was going on and did admit at trial that he should have been monitoring a little bit more. But once he found out that there was an issue with it, he took corrective action. So yes, kids make mistake under your supervision, and then if you take the corrective measures when you're aware of it to make sure it's not going to happen again, he's doing the right thing as a parent. So the kids do not have cell phones now, cannot use them at all. So all of that activity has stopped.
So that, I mean, that goes to best interest, but you're also saying that the judge was correct in saying there was no change in circumstances. I mean, are you?
Correct. I would say that a change of circumstances not occur. The issues in this case, especially mental health and the inappropriate searches on the internet primarily, did not rise to the level to change custody and send the child to North Carolina instead. There was no evidence that mom would have taken any other different action, and they didn't rise to the level of a change of circumstance. Just saying you have mental health issues is not a change.
Well, it wasn't just a mental health issue. I mean, there was a suicide attempt.
Correct, and she had no history before of self-harming, and she has none after. And so one instance alone is not enough to change
But
custody.
they are arguing that in conjunction with drop in grades, in conjunction with the stuff that's going on, the sexual stuff, the internet stuff, all of that, they're saying together is just this change of circumstances where there's a demonstration of lack of supervision.
Well, potentially, and I think that is maybe the reason why the magistrate made a decision and the judge disagreed, because I think it's a balancing act on that change. If you're going to piece all these little issues together that they combine to make a change, that could be a factual issue. I mean, we would argue that it's not. All these little things, especially on their own and even put together, is not enough to change custody.
But, well, I mean, you get to that, then you look at best interest.
Yes,
And
so
it
even
seems like
if-
that's your stronger argument, is that dad started doing stuff to rectify the situation.
Correct. I would agree with you, Your Honor. Even if you found that there was a change of circumstance, I absolutely do not believe it would be in the best interest to relocate the children to North Carolina and change custody.
And isn't that the key, at least in my mind? It's not so much the kids were doing these things, it's dad's reaction to them doing these things. And is it your point that dad's reaction, he was doing the best he can, he wasn't ignoring it?
Correct. Sometimes we make decisions as parents that are not correct in that exact moment, and I think at a short time period after, even if his reaction immediately wasn't perfect, he started to take the action. The issues are non-existent by the time it went to trial. And so I think that's a very important factor.
He started taking the action when the custody was challenged, right? I mean, that's when he started to do something.
Well, on the flip side, I truly believe that mom was building a case here for custody. I mean, it was testified in court by all parties, even herself, that she never contacted the school. She never went to a dance recital, participated in a parent-teacher conference until trial.
Well,
So I think that argument can be
I'm
flipped
going to
on
push
the other
back
side.
just a little bit on that. So she doesn't have custody of her kids. She lives 8 to 10 hours away from them by car. And when they came to visit her, she started seeing all of this really concerning stuff on their iPads. And, her older daughter had just, I don't remember if she was informed about the searches on the internet. And I don't remember if the spring break trip was before or after her attempted suicide. But she's seeing all of these really concerning things that any parent would be concerned about. So that kind of put her into, it's time for me to step up a little bit more, and because he's not fitting the bill here.
Well, I believe the record if she was tracking remotely, even if she couldn't make the changes, she saw them already happening. So I would argue that she was already aware before they came down.
Was there any testimony to that?
Yeah, I think they both testified that she could track them remotely. I think the issue what's contested is that she couldn't make the changes remotely in North Carolina. Like, she could only stop them if they came down or she was in person. We contest that's not even true, but that was what was the issue.
So she had the parental control set up before March 2023?
I believe so. I mean, if the record states differently, then That's what it is. But I know she had an app and she was following it.
Counsel, what about these two statements that Dad apparently made about the daughter being possessed by demons and then the threat to kick her out of the house?
The threat of the house, I mean, he didn't do it. I mean, I don't know if that was a heat-in-the-moment statement. I'm sure if he did state it, he wouldn't do it again. I mean, I think that goes back to my point that sometimes we say things that, aren't the best. He never did kick them out of the house. In fact, he tried to rectify the situation. And I'm not sure about that, but the demons. I mean, I would say that
Wasn't there some
it's an
allegation
inappropriate comment,
that
but
the father had said something about the child being possessed, and that's why they were doing what they were doing?
it's in the record. My response to that is, you shouldn't say something like that to your child, but I think all of his actions, not his words, have been helping the children, not hurting them.
Do you know anything about the in-camera with the children and the record? Do you have any insight on that?
I don't have any insight on it. I was not the attorney at the trial court level. That doesn't mean I wouldn't know any information about it, but it makes it harder.
Yeah.
But I would say that the judge in this case did indicate in her statutory factor analysis that they did interview the children and the court reviewed the interview. So I would assume that the judge did review it if that's what she put in her order.
We just don't have it.
Yes, you don't
It's
have
not
it.
up here to us.
And I know,
And we're supposed to have everything that the trial court reviewed.
so I was thinking about that in this case because I know that it's under seal and we can never see what happens, so.
It just comes to us usually.
It
yeah.
just comes to you guys. And both the magistrate and the judge, they said they reviewed it and took the
Well, the
judge is-
magistrate's the one that did the in-camera interviews.
Yes. So I'm not sure why I didn't get to you. I don't know if that means that that the judge didn't review it. She could have reviewed it and still, for some reason, didn't get to you guys.
Yeah.
And I would assume, if she said she reviewed it, that you did.
You have about a minute left.
I would also say that there was no Children's Services investigations or any police investigations of any wrongdoing. So I know there was mentions of neglect going on in this case, but in fact, father was never, and the school's mandatory reporters, mental health professionals are mandatory reporters, and there was nothing reported that father was doing anything inappropriate. In fact, the testimony at trial was that the kids were doing well, they had some issues, but they were fixed, and otherwise that they were doing very well under father's care. Thank you.
Thank you.
Before you start, I'm going to focus you in on a particular question I have. So opposing counsel is saying that, by the time of trial, all of the issues that had happened before were fixed. How do you respond to that?
I think the record speaks for itself, that that's just not an accurate reflection of what's in the record. If all the issues, the child was in therapy and went into therapy, either right at the start or just before trial or something like that. Now, the magistrate found that several of the things that father did, including his reactions to trying to deal with the children's issues, were a tactic for the trial. That was one of the specific findings that the magistrate made. And if the issues were fixed, the child wouldn't be in therapy, right? I mean, children aren't in therapy because everything's good. Children are in therapy because something's wrong and they're trying to fix it. So I don't think that really can hold true.
What about the grades? Were the grades going up?
There is nothing that I saw in the record that says that the grades were satisfactory by the time of trial.
Okay.
Now, if I'm wrong, and it's a long record and I'm trying to remember it all,
Look.
but there was lots of testimony about bad grades. There wasn't lots of testimony about, but they're good now.
What satisfactory, was a specific grade point average? I mean, were they failing?
So there were multiple failing grades were testified to, yes, and there were multiple near failing grades. So there were some failing grades and some near failing grades. So I don't know what near failing really means, but they're obviously not good grades, they're not A's. I think Judge Moore asked a question, and I think I want to touch upon it real quick, because I think it really gets to the heart of, I think the change in circumstances is kind of an open and shut deal. I think the best interest is the much more interesting issue, or the much more frankly challenging issue. to the extent there is a challenge. And I think the dad's reaction to incidents is what the best interest is going to be about in this case. And I think that defying medical advice, I think there was some advice given to one of at least a child involved in the relationship about avoiding being caught. I think there's been an admission that I'm too trusting of the children, an admission that I really can't make them do things that they don't want to do. These are admissions of the dad. This is not advocacy, this is just quoting. For best interest and harm versus benefits, it's just the same. It's always going to come out the same way. The dad's reaction to the children's problems is insufficient. And that's really where the best interest analysis should be focused on.
I mean, isn't that what Dad was admitting? He was frustrated that he couldn't take better care of the kids because of these situations that were completely foreign to him? Even on the medical advice, he's presented for the first time with a psychiatrist in treatment of his kid maybe he had some doubts and a pause. Should that really be held against him?
Well, but it's not, did the dad put in his best effort? That's not the standard. The standard is best interest of the children, right? So
And a parent putting forth their best interest or their best effort is in the children's best interest, is it not?
Right, but a woefully deficient best effort is still woefully deficient. The best interests of the children are what's at issue. If dad does his best and that's a really, really bad job, that's still a really, really bad job. And that means the best interests of the child, assuming that mother would do a better job, which I think the record comfortably reflects. So a parent who's doing their absolute best may still not be acting in the child's best interest, not because they choose to act in the child's worst interests or because they're choosing to not do a great job. That's just not the standard. The standard.
Let's talk about mom's reaction with respect to some of the apps. She had control over those.
I'm sorry. I just want to let you know my time's up. I'm happy to answer as many questions as you want me to. I'm just.
You can answer judges' questions. I was going to cut you off otherwise.
Thank you. I'm sorry. Sorry to keep you up there.
No, you're good.
But mom had control over these devices of some sort, correct?
That was not the testimony that Mum gave at trial. The testimony Mum gave at trial is she had a certain amount of viewing, but she needed the devices in her presence. And when they were in her presence, she did a deeper investigation and was able to cut off things, confiscate phones, disable devices. So the testimony from Mum was that she could not do that and didn't have control throughout the whole timeline, the whole process. But when she did have control, she reacted appropriately by cutting off access to his iPads and then controlling screen time by being physically present, taking away the phones at night. So that seems to me like a pretty solid reaction to bad behaviour with a phone is take away the phone, maybe there's a little bit of time because you want to connect with your friends back home, but that's going to be supervised. That seems like a pretty solid reaction rather than take it away for a day and then there's no question that Dad could have investigated and found out how to cut off the access or whatever, but he would just take it away for a day and give it back, or take it away for 2 days and give it back. And that was his testimony. Again, this is not advocacy. There's no doubt that's what happened. And that's not in the best interest of the child. Even if Dad thought it was appropriate, he was just wrong. And we're not talking about, oh, sorry, you put in your best effort, so we're gonna let you keep these children in this really dangerous situation. I can string it out for a little bit longer if I try hard enough, but I feel like I should probably say thank you and we ask you to call to reverse.
Thank you. Thank you both for your arguments this morning. The case is now submitted and we will issue a timely decision. All right, we're going to take a quick recess for Judge Zayas to come out for the final case.